1184 Appellate Review Chapter 16b The Notice and Time to appeal. Read Federal Rule of Civil Procedure 58, Rules 3, 4, and 5 of the Federal Rules of Appellate Procedure, and the accompanying materials in the supplement. Notes and questions. 1. Under Appellate Rule 3, what must the notice of appeal include? In Smith v. Berry, 502 U.S. 244, 112 S. Court 678, 116 L. Edition 2nd 678, 1992, an inmate, without consulting counsel, filed a notice of appeal, while a motion for judgment, notwithstanding the verdict, was pending in his civil rights suit. The clerk for the Court of Appeals responded to the notice of appeal by sending all of the parties copies of the informal brief that the court uses in pro se appeals, and appellant returned his informal brief to the appellate court within the deadline for filing a notice of appeal. After appointment of counsel for appellant, the Fourth Circuit dismissed the appeal for want of jurisdiction. The Supreme Court reversed, holding that an appellate brief may serve as a notice of appeal under Appellate Rule 3 when it gives notice of the litigant's intent to seek review. On remand, the appeals court held that the informal brief sufficed as a notice of appeal with respect to 6 prison guards, but not to a prison psychologist. The informal brief asked for a new trial on all issues triable by jury, but did not mention a doctor, and so notice was not provided. Smith v. Berry, 985 F. 2nd 180, 184, 4th C. 1993, cert. Denied. 510 U.S. 874, 114 S. Court 207. 126 L. Edition 2nd 164. 2. In Torres v. Oakland Scavenger Co., 487 U.S. 312,108 S. Court 2405, 101 L. Edition 2nd 285, 1988, the court held that the Court of Appeals lacked jurisdiction over a litigant in a purported class action when the notice of appeal under Appellate Rule 3, C, used the term "and others," rather than listing the names of all of the appellants. The fact that the omission was due to a clerical error by the secretary, employed by the litigant's attorney, did not provide grounds for waiver. Although Appellate Rule 3, C, was amended in 1979 to add that an appeal shall not be dismissed for informality of form or title of the notice of appeal, the court emphasized that the failure to name a party in a notice of appeal is more than excusable informality. It constitutes a failure of that party to appeal. Is a court's decision consistent with the spirit of Appellate Rule 4? 2. Does the failure to list the parties' names in the notice of appeal raise due process concerns? 3. What is the effect of a notice of appeal if it is filed before entry of judgment? See Appellate Rule 4. 2. The leading case on the effect of a premature notice of appeal, at least when the appeal is taken under 28 U.S.C. 1291, is First Year Mortgage Co. v. Investors Mortgage Insurance Co., 498 U.S. 269, 111 S. Court 648, 112 L. Edition 2nd 743, 1991. The court stated, Secretary. B. The notice and time to appeal 1185 in our view, Rule 4. 2. Permits a notice of appeal from a non-final decision to operate as a notice of appeal from the final judgment only when a district court announces a decision that would be appealable if immediately followed by the entry of judgment. In these instances, a litigant's confusion is understandable, and permitting the notice of appeal to become effective when judgment is entered does not catch the appellee by surprise. Edit 276, 111 S. Court at 653, 112 L. Edition 2nd at 753. However, the court went on to say that Appellate Rule 4, 2, does not permit a premature notice of a PPE-L from a clearly interlocutory decision such as a discovery ruling or a sanction order under Rule 11, because of "leaf that such a decision is a fatal judgment reabonable." Edit 276, 111 S. Court 648, 112 L. Edition 2nd at 763. 4. How does the filing of a post-judgment motion affect the time to file an appeal? See Appellate Rule 4. 4. Whether a "JTM CT on DICSONI Co.N86 URI 9 L7L LZ.SL 78 138S the Ramato L Tetrades 1 and plaintiff filed a notice of appeal on August 29. Citing, among other cases, IZ, EEP 1172, Supra, the court found that the May 14th order was a final judgment and dismissed the appeal as to all issues other than attorney fees. We are not inclined to adopt a disposition that requires the merits on under its status of each attorney's fee provision to be clearly established before finality can be determined. Courts and litigants are best served by the bright line rule, which accords with traditional understanding that a decision on the merits is a final decision purposes of 1291, whether or not there remains for adjudication a request for attorney's fees attributable to the case. Edit 202, 108 S. Court at 1722, 100 L. Edition 2nd at 185. 5. Appellate Rule 4, 5, permits the district court to extend the filing period, but only upon a finding of excusable neglect or Goa cause Pioneer Investment SERVS, Co. v. Brunswick Associated, Limited, 507 US 380, 113 S Court 1489, 123 L edition 2nd 74, 1993, concerned the late fee milligrams of a proof of claim in the bankruptcy court. The Supreme Court found excusable neglect on the basis of a balancing of 4 factors: the parties G-D faith, the absence of any danger of prejudice to the opposing party, J1GT of the filing delay and its effect on the proceeding, and the reason for the delay. Bowles v. Russell, 651 US 206,127 S Court 2360, 168 L ed. 2nd 9,672,007. The Supreme Court made clear that the District Court's ATHOBTY to grant an extension of time is limited by the time period set out M statute injected as untimely a notice of appeal filed outside the statutory period but in conformity with the District Court's order. The Bowles rationale is in separation of powers and does not apply to time limits as which are treated as claim processing rules and may be subject to forfeit too. 1186 Appellate Review Chapter 16 C. Hammer v. Neighborhood Services of Chicago, 138 S Court 13, 199 L edition 2nd 249, 2017.6. In 1963, and again in 2002, Federal Rule 58 was amended to clarify when a judgment is considered entered, and thus the time for appeal begins to run. When is a separate document not required for a judgment? C. The ambit of appellate review. 1. Issues subject to review. There are a number of well-defined limits on the scope of appellate review. First, the alleged errors must appear in the trial court record. Thus it is vital during the course of pretrial preparation as well as during trial itself that an attorney makes certain that all rulings and evidence that might form the basis for an appeal be formally recorded. Second, an aggrieved party must have objected promptly to the trial court regarding rulings or events that the judge could have corrected or ameliorated. Normally an error is waived unless a proper objection was taken. Third, even if the issue that the appellant seeks to have reviewed has been presented properly below and has not been waived, it must not constitute harmless error, that is, it must have affected substantial rights. Finally, an alleged error must be presented to the appellate court in appellant's brief and the relevant portions of the trial court record must be brought to the appellate court's attention. Notes and questions. 1. What justification is there for a rule that a party may not raise an issue on appeal that was not raised in the trial court? Is it fair to penalize the party for what is likely a lawyer's error? 2. If a party has presented undisputed facts or facts necessarily determined at trial for that party which sustain a claim or defense on a theory not argued at trial, should the appellate court be permitted to make its determination on the basis of the new theory? 3. What underlies a rule that an error, if harmless, will not provide a basis for reversal? Is it really possible for an appellate court to determine what would have affected a jury's determination? Does this rule give the appellate court broad latitude to disregard error below, undermining the appellate system's error correction function? Or does the rule make it possible for an appellate court to instruct lower courts without needlessly incurring the costs of a new trial, even when the appellant has properly preserved issues in the trial court and presented them to the appellate court for review? There is another secretary. See the ambit of appellate review. 1189 Significant involvement with the judgment. Plausible reasons for not becoming involved earlier. A risk that its interests will not be adequately protected by the parties, and a lack of untoward interference in the affairs of the parties. Does the analysis change if the non-party is the subject of a order? See Steinman, Irregulars, the appellate rights of persons who are no full-fledged parties. 38 Gap.L. Reverend 411, 2005. International Law and Fertilizer Corp. v. SGS Control Services Incorporated. United States Court of Appeals. 2nd Circuit, 1994. 38 F. 3rd 1279. Winter, Circuit Judge. Defendant agreed to transport a cargo of fertilizer for Carrotbire in New Zealand. Defendant's ship had not been cleaned sufficiently, with the result that the cargo was contaminated, and the purchaser refused delivery, resulting in damages to plaintiff. Plaintiff sued defendant both for BREACH Carrot OF contract and for negligent misrepresentation of the condition its ship after evidence was presented. The trial judge rejected the contract claim, but upheld the claim of negligent misrepresentation and awarded damages. Defendant appealed. The appellate court held that the misrepresentation claim should have been dismissed and determined that the contract claim, which would have justified a large plaintiff, should have been upheld. However, the court was faced with argument that it could not rule on the contract claim because plaintiff had not filed a cross appeal. The general rule in a case in which a party fails to cross appeal and an appellate court would otherwise have held in its favor is that a party who does not appeal from a final decree of the trial court cannot be heard in opposition thereto when the case is brought here by the appeal of the adverse party. In other words, the appellee may not attack the decree with a view either to enlarging his own rights thereunder or of lessening the rights of high adversary, whether what he seeks is to correct an error or to supplement the decree with respect to a matter not alt with below. But it is likewise settled that the appellee may, we taking a cross appeal, urge in support of a decree any matter appearing in the record. Although his argument may involve an attack upon the reasoning of the court or an insistence upon matter overlooked or ignored by it. United States v. American Chi. Expressco, 265 US 425, 44 S Court 560, 563, 64, 68 L edition 1087, 1924. 1190 Appellate Review CH 16. This rule has been modified in some circuits by treating the requirement of a cross appeal as one of practice rather than jurisdiction, allowing the court to use its discretion to consider unappealed grounds so as to exercise its broad power to make such a disposition as justice requires, generally. However, these cases have involved multiple parties where only one of several plaintiffs or defendants failed to cross appeal. In each case, the court included the non-cross appellant in the amended judgment so as to preserve fairness. Several of our recent decisions have referred without elaboration to the discretionary nature of our power to disregard the cross-appeal requirement. These cases conform to the general rule that the appellee may seek to sustain a judgment on any grounds with support in the record. This rule applies even when the alternative grounds were not asserted until the court's questioning at oral argument. We may, therefore, uphold the finding of liability on a breach of contract theory. We do not believe, however, that given the present procedural circumstances, plaintiff is entitled to its full damages. Although an appellee who has not cross-appealed may urge alternative grounds for affirmance, it may not seek to enlarge its rights under the judgment by enlarging the amount of damages or scope of equitable relief. We may therefore uphold the present judgment, but we may not enlarge it to award plaintiff its full contract damages. Notes and questions. 1. Is the rule that a cross-appeal must be filed to change the amount awarded as damages a matter of practice or of jurisdiction? Is it significant that arguments that support the judgment as entered can be made without a cross-appeal? Is a cross-appeal necessary to secure post-judgment interest denied by the district court? Consider the effect of Appellate Rule 37. Is a cross-appeal necessary to challenge the subject matter jurisdiction of the district court? 2. Consider the effect of TORS. Note 2, P 1184, supra, on the power of the appellate court to excuse a failure to file a separate notice of appeal. In the light of the court's holding that a notice of appeal listing 15 of the 16 plaintiffs plus an others did not support an appeal by the one unidentified plaintiff, does a court of appeals have power to enter relief to a party who is not named in a notice of appeal? Seconds. See the ambit of Appellate Review 1191. 2. Review of fact-finding. Read Federal Rules of Civil Procedure 52 and 59 and the 7th Amendment to the United States Constitution in the supplement. A. Fact-finding in cases decided by a jury. Corcoran v. City of Chicago Supreme Court of Illinois, 1940, 373 Illinois, 567, 27 NE 2nd 451. Murphy, Justice. John F. Corcoran began a suit against the City of Chicago to recover damages for personal injuries alleged to have been caused by the negligent acts of the defendant. The cause was tried with a jury and resulted in a verdict for the plaintiff for $5,000. A motion for new trial was overruled, and judgment entered on the verdict on appeal. The appellate court for the First District reversed the judgment and remanded the cause for another trial. The plaintiff filed a motion in the appellate court asking that the remanding part of the order be stricken in order that on appeal to the state Supreme Court, that court could then order that the initial verdict be reinstated. The motion was granted. The negligence charged was that defendant had carelessly and negligently permitted certain streets to be and remain in an unsafe condition for travel. The evidence was conflicting. The appellate court found the verdict was against the manifest weight of the evidence and reversed the judgment for that reason. It is conceded the power which the appellate court assumed to exercise in reviewing the evidence and setting aside the verdict is found in Section 92, 3b, of the Civil Practice Act, which provides that appellate courts may review error of fact in that the judgment, decree, or order appealed from is not sustained by the evidence or is against the way of the evidence. Plaintiff's position is that such provision, as applied to facts found by a jury upon conflicting evidence, as in Carrot Instant case, is unconstitutional, in that the findings of the appellate court take from him the right to a trial by jury as guaranteed by Section 5 of Article 2 of the Illinois Constitution. KFK. Prior to 1837, the law of this state was that the granting or refusal of a motion for a new trial rested in the sound discretion of the trial court and the ruling thereon could not be urged as error in the court of review. 1192 Appellate Review Chapter 16 in 1837, an act was passed which provided exceptions taken to opinions or decisions of circuit court overruling motions in arrest of judgment, motions for new trials, and for continuance of causes, shall hereafter he allowed, and the party accepting, may assign for error any opinion so accepted to any usage to the contrary notwithstanding. The substance of the act has been the statutory law of this state since 1837. IKIT. The effect of the operation of the statute was considered in Chicago and Rock Island Railroad Co. v. McKean, 40 Illinois 218, a case where the trial court had overruled a motion for new trial and error was assigned on such ruling. Mr. Justice Breeze, speaking for the court, said an appellate court was, before the passage of that act, judge of the law only. The old and honored maxim once was, the judges respond to the law, the jury to the facts, but now, by this innovation, the judges of an appellate court have as much power over the facts as the jury had in the first instance, for it is undeniable this court may set aside a verdict, if the facts fail to satisfy it of its propriety. Plaintiff contends that on all questions of fact, where the evidence is conflicting, the verdict of the jury cannot be set aside as being against the weight of the evidence, except by the court that tried the case, and asserts that such was the practice at common law. It did it from the authorities cited, and others which have been examined. We conclude that there was a practice at common law which authorized courts exercising appellate jurisdiction to set aside verdicts on the grounds the findings of fact were not supported by the evidence. Judgment affirmed. Point notes and questions. 1. How does the reviewing court's role differ when the trial court has denied the motion for a new trial on the weight of the evidence, and when it has granted the motion? C. Carrington. The power of district judges and the responsibility of courts of appeals. 3. L. Reverend 507. 1969. Schnapper. Judges against juries. Appellate review of federal civil jury verdicts. 1989. Wissell Reverend 237. 298 to 313. 2. In the federal system, the appellate court applies an abuse of discretion standard in reviewing the district court's denial of a Rule 59 motion for a new trial based upon the excessiveness of the jury's compensatory damage award, giving the benefit of every doubt to the judgment of the trial judge. Gasparini, p. 453, supra. Whether a jury award is excessive is considered to be a question of law. See Cooper Industries Incorporated v. Leatherman Tool Group Incorporated, 532 U.S. 424, 121 S. Court 1678, 149 L. Edition 2nd 674, 2001, in which the court stated, because the jury's award of punitive damages. Does Secretary CTHB Ambit of Appellate Review 1193 not constitute a finding of fact, appellate review of the district court's determination that an award is consistent with FDFS at the 7th Amendment at 437, 121 S. Court at 1687, 149 L. Edition 2nd at 687 to 88. B. Fact findings in a non-jury case. Pullman Standard v. Swin Supreme Court of the United States, 1982, 456 U.S. 273, 102 S. Court 1781, 72 L. Edition 2nd 66. Certiorari to the United States Court of Appeals for the Fifth Circuit. Justice White delivered the opinion of the court. Respondents were black employees at the Bessemer, Alabama plant of petitioner, Pullman Standard, the company a manufacturer of railway freight cars and parts. They brought suit against the company and the union petitioners alleging violations of Title VII of the Civil Rights Act of 1964. As they come here, these cases involve only the Title VII of a seniority system maintained by the company and USE United Steel Workers of America. The district court found that the differences in terms, conditions, or privileges of employment resulting from the seniority system are "not the result of an intention to discriminate because of race or color," and held, therefore, that the requirements of 703(h) of the Act, the Court of Appeals for the Fifth Circuit reversed, because we find that the differences in the terms, conditions, and standards of employment for black workers and white workers at Pullman Standard resulted from an intent to discriminate because of race. We hold that the system Section 703(h) of Title VII, 42 U.S.C. 2000E-2, 624 F. 2nd 525, 533 to 534, 1980. We granted the petitions for certiorari limited to the first presented in each petition, whether a court of appeals is bound by the clearly erroneous rule of Federal Rule 52, in reviewing a district court's findings of fact, arrived at after a lengthy trial, as to the of the parties who negotiated a seniority system, and whether the court below applied wrong legal criteria in determining the bona fides of the seniority system. We conclude that the Court of Appeals erred in the course of its review and accordingly reverse its judgment and remand for further proceedings. In connection with its assertion that it was convinced that a mistake had been made, the Court of Appeals, in a footnote, referred to the clear erroneous standard of Rule 52. It pointed out, however, that if 1194 Appellate Review Chapter 16 findings are made under an erroneous view of controlling legal principles, the clearly erroneous rule does not apply, and the findings may not stand. Finally, quoting from East v. Romine Incorporated, 518 F. 2nd 332, 339, CA 5, 1975, the Court of Appeals repeated the following view of its appellate function in Title VII cases, where purposeful discrimination is at issue. Although discrimination vel non is essentially a question of fact, it's, at the same time, the ultimate issue for resolution in this case, being expressly proscribed by 42 U.S.C.A. 2000E-2. As such, a finding of discrimination or non-discrimination is a finding of ultimate fact. Cite submitted. In reviewing the district court's findings, therefore, we will proceed to make an independent determination of appellant's allegations of discrimination, though bound by findings of subsidiary fact which are themselves not clearly erroneous. 624 F. 2nd, at 533, N6. Petitioners submit that the Court of Appeals made an independent determination of discriminatory purpose, the ultimate fact in this case, and that this was error under Rule 52. We agree with petitioners that, if the Court of Appeals followed what seems to be the accepted rule in that circuit, its judgment must be reversed. Rule 52 broadly requires that findings of fact not be set aside unless clearly erroneous. It does not make exceptions or purport to exclude certain categories of factual findings from the obligation of a court of appeals to accept a district court's findings unless clearly erroneous. It does not divide facts into categories. In particular, it does not divide findings of fact into those that deal with ultimate and those that deal with subsidiary facts. The rule does not apply to conclusions of law. The Court of Appeals, therefore, was quite right in saying that if a district court's findings rest on an erroneous view of the law, they may be set aside on that basis. But here the district court was not faulted for misunderstanding or applying an erroneous definition of intentional discrimination. It was reversed for arriving at what the Court of Appeals thought was an erroneous finding as to whether the differential impact of the seniority system reflected an intent to discriminate on recount of race. That question, as we see it, is a pure question of fact, subject to Rule 52's clearly erroneous standard. It is not a question of law, and not a mixed question of law and fact. Rule 52 does not furnish particular guidance with respect to distinguishing law from fact, nor do we yet know of any other rule or law principle that will unerringly distinguish a factual finding from a legal conclusion. For the reasons that follow, however, we have little doubt about the factual nature of 703(h)'s requirement that a seniority system be free of an intent to discriminate. As an original, Secretary, CTCTF, Ambit of Appellate Review 1195, it would make no sense to say that the intent to discriminate required by 703(h) may be presumed from such an impact as 703 was construed in International Broth of Teamsters v. United States, 431 U.S. 324, 97 S. Court 1843, 52 L. Edition 2nd 396, 1977. There must be a finding of factual intent to discriminate on racial grounds on the part of those who negotiated or maintained the system. That finding appears to us to be a pure question of fact. This is not to say that discriminatory impact is not part of the evidence to be considered by the trial court in reaching a finding with such a discriminatory intent as a factual matter. We do assert, however, that under 703(h), discriminatory intent is a finding of fact to be made by the trial court. It is not a question of law, and not a mixed question of law and fact of the kind that in some cases may allow an appellate court to review the facts to see if they satisfy some legal concept of discriminatory intent. Discriminatory intent here means actual motive. It is not a legal presumption to be drawn from a factual showing of legal motive. Thus, a court of appeals may only reverse a district court's finding on discriminatory intent if it concludes that the finding is clearly erroneous under Rule 52. Insofar as the Fifth Circuit assumed otherwise, it erred. Respondents do not directly defend the Fifth Circuit rule that a trial court's finding on discriminatory intent is not subject to the clearly erroneous standard of Rule 52. Rather, among other things, they submit that the Court of Appeals recognized and, where a ROPRIATE, proper why applied Rule 52 in setting aside the findings of the district court. Position has force, but for two reasons it is not persuasive. First, although the Court of Appeals acknowledged and correctly stated controlling standard of Rule 52, the KNOWLEDGEMENT came late in the court's opinion. The court had not expressly referred to or applied Rule 52 in the course of disagreeing with the district court's resolution of the factual issues deemed relevant. Furthermore, the paragraph in which the court finally concludes that the USW seniority system is unprotected by 703(h) strongly suggests that product of the court's independent consideration of the totality of the circumstances it found in the record. Second, and more fundamentally, when the court convinced that a mistake had been made, it then mistake, but also the source of that mistake. The mistake of the district court was that on the record there could be no doubt about the existence of a discriminatory purpose. When an appellate court discerns that a district court has failed to make a finding because of an erroneous view of the law, the usual rule is 1196 Appellate Review Chapter 16 that there should be a remand for further proceedings to permit the trial court to make the missing findings. Likewise, where findings are infirm because of an erroneous view of the law, a remand is the proper course, unless the record permits only one resolution of the factual issue. All of this is elementary. Yet the Court of Appeals, after holding that the district court had failed to consider relevant evidence and indicating that the district court might have come to a different conclusion had it considered that evidence, failed to remand for further proceedings. Instead, the Court of Appeals made its own determination and findings and apparently concluded that the foregoing was sufficient to remove the system from the protection of 703(h). Proceeding in this manner seems to us incredible, unless the Court of Appeals construed its own well-established circuit rule with respect to its authority to arrive at independent findings on ultimate facts free of the strictures of Rule 52, also to permit it to examine the record and make its own independent findings with respect to those issues on which the district court's findings are set aside for an error of law. As we have previously said, however, the premise for this conclusion is infirm. Whether an ultimate fact or not, discriminatory intent under 703(h) is a factual matter subject to the clearly erroneous standard of Rule 52. It follows that, when a district court's finding on such an ultimate fact is set aside for an error of law, the Court of Appeals is not relieved of the usual requirement of remanding for further proceedings to the tribunal charged with the task of fact-finding in the first instance. Accordingly, the judgment of the Court of Appeals is reversed, and the cases are remanded to that court for further proceedings consistent with this opinion. So ordered. Justice Stevens concurred in part. Justice Marshall dissented, and Justice Blackmun joined in part. The gist of the dissent was that the evidence was documentary, and thus the appellate court was in an equally good position to determine the facts as was the trial judge. Inwood Laboratories, Incorporated v. Ives Laboratories Incorporated, 456 U.S. 844, 102 S. Court 2182, 72 L. Edition 2nd 606, 1982. In a trademark infringement suit brought by Ives Laboratories against Inwood Laboratories, the district court entered judgment for defendant, finding that plaintiff had not made the necessary factual showings. The Court of Appeals reversed, making its own review of the evidence, and finding the evidence clearly sufficient to establish a violation. The Supreme Court Chapter 17 The Binding Effect of Prior Decisions, Res Judicata and Collateral Est Appel. This chapter focuses on the binding effect of prior judgments and the twin doctrines of res judicata and collateral est appel, now known as claim preclusion and issue preclusion. The materials examine the doctrine, its history, and the policies that support the concept of finality. The chapter opens by examining the reach of claim and issue preclusion within a single court system, and closes by widening the scope to examine the inter-system effects of a judgment, surely one of the most difficult and vexing questions in the entire procedure course. As you learn about preclusion, consider this insightful statement about the doctrine. Courts can only do their best to determine the truth on the basis of the evidence, and the first lesson one must learn on the subject of res judicata is that judicial findings must not be confused with absolute truth. Curry, Mutuality of Collateral Est Appel Limits of the Bevenard Doctrine, 9 Standpoint L. Reverend 281, 315, 1957. A terminology. Although the doctrine of former adjudication is complex, 4 common sense principles explain it. First, a party ordinarily gets only one chance to litigate a claim. If a party litigates only a portion of a claim the first time around, the party risks losing the chance to litigate the rest. Second, a party generally gets only one chance to litigate a factual or a legal issue. Once litigated, a party cannot ask a second court to decide it differently at a later point. Third, a party typically is entitled to at least one full and fair chance to litigate before being barred from having the claims and issues heard by a court. And fourth, the defense of preclusion may be waived unless it is raised at an early stage of the litigation. The effects of a former adjudication have been discussed in varying and occasionally conflicting terminology. Although a single vocabulary is still not used, substantial progress has been made toward a convention. Res judicata is used as a general term referring to all of the ways in which one judgment will have a binding effect on another. That usage is, and doubtless will continue to be common, but it lumps under a single name to quite different effects of judgments. The first is the effect of foreclosing any litigation of 1207, 1208 the binding effect of prior decisions, res judicata and collateral est appel chapter 17 matters that never have been litigated, because of the determination that they should have been advanced in an earlier suit. The second is the effect of foreclosing relitigation of matters that have once been litigated and decided. The first of these, preclusion of matters that were never litigated, has gone under the name, true res judicata, or the names, merger, and bar. The second doctrine, preclusion of matters that have once been decided, has usually been called collateral est appel. Professor Alan Vestal has long argued for use of the names claim preclusion and issue preclusion for these two doctrines, and this usage is increasingly employed by the courts as it is by Restatement Second of Judgments. Wright and Kane, Law of Federal Courts LOOA, 8th edition,